Rise. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within for the Commonwealth. Draw near, give attendance, and you shall be heard. Now see the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning. Welcome to the Appeals Court. I am Justice Rubin. To my right, Justice Massing. To my left, Justice Toone. We will be hearing 6 cases this morning. The first of which is MACKAY versus Ford, number 25303. The rules are, as they always are here, 15 minutes per side and no rebuttal. We have read your briefs with some care, so you may want to get right into your argument rather than repeating facts that we might know, but it's your time and you can do as you wish. And with that, we will hear first from, I believe, Attorney Schley.
Thank you, Your Honors. I'm Glenn Schley with Warner, Federico, and Ryan. I'm here to speak on behalf of the appellant, Deborah Ford. I'm asking the court today to vacate paragraph 2 of the judgment of contempt entered October 15th, 2024, and enter an order that the defendant be found in contempt for his failure to pay alimony on income from stock options that were at the time that they vested, along with statutory interest. And I appreciate the court's review of the papers, and I don't mean to repeat necessarily what's in our briefs, but the point that we have here, the primary issue, is the term, whether a term is ambiguous in the separation agreement entered into between the parties. The parties were divorced in 2016, and in their separation agreement had provisions for the payment of alimony. That alimony structure in the agreement is what is at issue in the appeal. This was a alimony provision that survived as a contract between the two and was not modifiable by the court. And within it, we had an alimony order that was what we consider itself self-modifying. It had provisions based on a percentage of income to be paid, and based on that certain definition of income, within that definition of income, clearly and unquestionably included stock options and equity incentives. That's not in dispute. What is at dispute in terms of the definition is necessarily when those options or equity incentives are received, when do they become income for purposes of entering into the alimony calculation.
Are we just talking about the Avro Bio RSUs? Is that really what, there's nothing else at stake?
That's really what it's at issue here and moving forward through the end of the alimony term.
And can you just tell me, I'm trying to understand what's at stake financially, because you write in your brief that the wife received alimony based on the value of the husband's stock options upon vesting, but the stock options were included in the alimony formula after the husband chose to liquidate them, which occurred at a lower market value and became subject to the alimony cap. Is there evidence in the record about it being at a lower market value when they were actually, when she actually received
Yes,
alimony?
during the trial, there was judicial notice taken of the value of the stock at various times, which were higher at the times when they had been paid out during vesting, as opposed to taking them all in a single tranche when they were actually
How much of a difference are we talking about?
I don't have that number as part of my calculations. I'm looking at the kind of the issue of the question of law, whether that is to be included. It was, to my understanding, a significant figure. Enough so that it should be reviewed and looked at, not only now, but going forward. Particularly when you have an issue of, when you're looking at when these stock options are put into place. for the alimony calculation, you can have a great degree of manipulation that can go into it.
Before you get into that, you mentioned the judge took judicial notice of the stock prices. Do we have that anywhere in the record?
Yes, it is.
Where is it?
I don't have the exhibit number, but it's the entire trial record and the.
It was an exhibit?
It is in there.
Any indication
It's
towards
actually, it's an order entered by the court allowing a motion for judicial notice.
Right, but I mean, do we actually have the numbers? On a piece of paper? In the record?
I believe so, Your Honor. I believe so.
But you don't know where it is?
I don't have those
Okay,
numbers.
well, maybe the other side knows.
That-
So,
Go ahead, sorry.
So when it says, if no further event is needed for husband to liquidate, what further events does that contemplate? The parties put that language in, so they must have meant it. They must have thought it meant something. So what events were they talking about when that was put in?
I mean, clearly, so once looking at the actual resolutions made by the board, the stock plan that actually governs the options that were granted, and there are no actual further events that's listed there, but we do know some just in generalities that this is a small cap company, that you've got a requirement that you don't do insider trading, that you're not going to violate SEC rules.
So what event is contemplated about SEC rules?
Well, if there is,
I mean, right? Because if you can't tell me what that means, then that sort of makes me think it is ambiguous.
I think I can tell you what it means, because we're going to use the ordinary sense of the words, as has been the precedent since 1927 when we look at a contract term.
Right. So what
Any
further events are contemplated?
So
Events, things happening.
happening would be that if he can't do anything with his stock because there is something implemented by either their board of directors or by the actual making an illegality for him to liquidate the options. That would be an event that would be.
I don't know about that board of directors one, because it seems like he's on the board of directors, and I would have thought you'd say anything he can do himself can't be an obstacle.
True, that's why
Right,
I believe
okay.
it's.
So
But you also have to understand that this term relates to, while at the time he was working for this company. This was something that was to last through the entire alimony
in general, I
term.
don't know
It
if
could
you
be
know
any-
the answer to this. In general, when stock options vest, are they usually freely liquidatable or not?
Yes,
They ordinarily are.
they are. He has, if he
I'm not
has,
talking about these stock options. I'm asking in general, when people get stock options, this is I don't remember, closely held or publicly traded?
it's publicly traded.
Okay, in a publicly traded company, can they usually exercise those options the minute they vest? So you're saying the future event that you think is anticipated by this, because I was thinking maybe this is some kind of boilerplate, because there are frequently future events with stock options, and so you want to make sure you're covered. It doesn't say just RSU or whatever it is, stock options, it just says stock options. He could change jobs and have stock options from someplace else. You're saying that the event would be the expiration of the bar on selling under the SEC rules. So if he can only sell during certain windows and he isn't during one, when the window opens is when he can liquidate without a further event. Before that, he has to wait for the window to open.
Right.
That's your idea?
So there's no other limitation on his rights to exercise.
And even when that happens, he doesn't have to liquidate them right then, because if there's a future event, he gets to liquidate them whenever he wants, and your client suffers the consequences if there are any.
I'm sorry, can you say that again?
Well, I don't know why you were close to the cap in the year at issue here, or when these were liquidated. But he could wait till he's at the cap, and
Yes.
that be the time he does it, and although it might count as compensation, your client won't benefit from that.
That's correct.
Okay.
And that's a primary concern. Looking at the term that put into this. It's looking at all of the words. We have upon vesting is the impetus. Then we have qualifications to that when we look at that term for this, when these will be included in income. When you have that, it's this, further event before I can liquidate. It's a, is there something that will require, like you said, an event that falls into place that prevents it?
So there has to be some kind of SEC rule that would say, no, husband cannot liquidate until X day, right? That's your position, right?
It's not necessarily just an SEC rule.
What else could it be?
If the board entered a new resolution that said that we're not allowing you to exercise and liquidate your options that have been granted, although they've vested.
Wouldn't somebody sue them right away? Aren't these granted under some kind of contract?
They are granted under a contract.
So they can't change the terms of it post facto, can they?
But they could have they were divorced in 2016. Any future grants could have had different terms that would have come with them. And if those terms came.
I'm sorry, I didn't mean to interrupt. Go ahead,
Okay.
finish. But are you done? Because I have another question.
Please go ahead.
Okay. So what you're not saying that the husband has to liquidate them. You're saying that as soon as he's able to liquidate them, then the wife's entitled to alimony based on this market value minus the strike price, right?
That's precisely the point, because that takes away the ability to manipulate when you can liquidate them as to take advantage of the construct of the alimony. And when you have that is the kind of key term in the provisions in the agreement. It's deemed to be received. It's not upon actually liquidating, upon actually realizing it. It's deemed to be received. That's when it goes into the alimony calculations. That's when it goes into the formula. That's when it becomes payable. That's what didn't happen in this case. Now we have what then happened was that the trial judge found this term to be ambiguous because there was no separate definition for further events upon vesting. And in doing so, then changed the order so that it was not when it was deemed to be income, but when it was actually liquidated. And by doing that, essentially took away the intent of the parties in the agreement and put in a different term that allowed for exactly what they were trying to prevent. They're trying to to pick a time that that there's no dispute about. It's about for the time that it's vesting and when you can actually enforce the rights that come with those contractual terms with those grants.
I know you argue that the judge effectively modified the agreement by this ruling, but you're not challenging the actual modifications that the judge made to the agreement, right? Regarding the deviation from the alimony year calculation prescribed by the agreement, right? You're not challenging that.
I'm sorry, can you say that last part again?
You're not challenging the actual modifications that the judge entered. You're just sort of saying this was effectively a modification of the terms of the agreement, and it was wrong for that.
The provision that I'm challenging is changing the timing for when you deem the stock options to be income. She changed it from upon vesting with no further events to liquidate to only upon liquidation.
Okay, but that's in essence her denying this aspect of the contempt motion, right? There was an actual ruling that changed the language.
That's paragraph 2 of her contempt judgment that actually enters that order.
Okay. Can I ask you about this other provision in the agreement? After we get through, if no further event is needed for husband to liquidate the asset, and it says, and if applicable, the board endorses such liquidation or otherwise upon there being, if ever, a liquidating event. So what does that mean?
So I think the provision says if the board were to say our endorsement is required for you to liquidate, then that could be a further event that would be included.
Okay.
And
why would you? I mean, it seems to be it's a different clause than the further event clause, right? So it's a different circumstance.
Right. And so there's there's two pieces at play here. It's a board member talking about his own compensation and saying that, where it's the construct of being, is it something that he has the right to as income? That's what he agreed to, versus this is what, in my subjective opinion, should be when we make it income.
I don't understand what your answer is to Justice Toone about and a board endorsement if necessary.
So there was testimony at trial that he did not have consent of the board to liquidate his shares. The premise, though, there was nothing on the record in the trial that actually said that any endorsement would be required to liquidate his shares. As we said before, there's a contract, he has rights upon vesting. And that's the kind of tug and pull between, is it when he wants to exercise the shares versus when he's able to?
But that second clause about board endorsement, since it says or, suggests that a board endorsement is not a future event within the meaning of the prior clause, or you wouldn't need to say.
Right, or they wouldn't have put in if applicable. Because if it became applicable, then certainly that would be.
It wouldn't be a future event because it's under a separate piece of language, right? I wouldn't say to you, you have to wear a suit or a blue suit, right? That doesn't make any sense, right? To have a subset of the first one be an or.
It's still a provision of not just the grants that existed at the time of the divorce, but any that came forward.
We need to figure out what future event means, though. But your time has expired. Thank you very much.
I appreciate the court's time. Thank you.
We will hear next from Attorney Faulkner, I believe.
Good morning, Your Honors. May it please the Court, my name is Claire Faulkner of the firm Lee & Rivers, and I, along with Robert Rivers with me, represent the appellee in this matter. You're being asked by the appellant to find error, notwithstanding a judgment based on evidence, lengthy and detailed findings, and rationale. In fact, it's a 79-page document. Our position is straightforward. The trial court's decision was the correct one. Judge Burchell applied the law and wrote an informed judgment which should be upheld and affirmed by this trial court. This morning, I will address 3 points which support our position that the court's judgment should be upheld. First, the judgment clarifies when the husband is to pay alimony to the wife, as the trial court is empowered to do so under our case law, including Colorado v. Marks and Pedersen v. Clare. And in so doing, the court provided the wife with certainty of receipt of alimony in the future. Clarification.
Well, certainty, I mean, couldn't your client choose not to liquidate at all?
I think the language is clear in the judge's paragraph 2 of the judgment that he has to do something upon liquidation. And the agreement.
What if he doesn't liquidate?
Well, the parties' separation agreement in Exhibit A, paragraph 9, talks about the fact that if there's not good faith and fair dealing, then which the husband is required to act under pursuant to that alimony exhibit in the original agreement, then the wife can file a complaint for contempt.
What if he says these are very valuable? They're only going up in value. I love stock in our company, but I don't feel like spending the money to liquidate, or I don't want to pay the taxes this year. I'm going to wait till I retire. Or, I mean, there's a million things that I don't know how you'd find them to be in bad faith.
I think that would be a question for the trial court, but I do think
whether it's bad faith, but that's the only limit.
Well, as is brought out, there's also the limit of the $1.4 million cap that he has for alimony in any given year. But on that point, Your Honors, his salary could go increase. He could get a huge bonus. Even if he were to liquidate in a year, the wife could still not get her share of the alimony from the stock options or the RSUs if, in fact, he already had made $1.4 million and she'd already gotten her maximum amount of alimony in any given year.
I was going to save it for the end, but since we're here already, you said that the wife could enforce the judge's modification, but by claiming a breach of the covenant of good faith and fair dealing.
Yes, sir.
Is that an clear and unambiguous directive?
I think it's very clear and unambiguous, not only under our case law, but under the separation agreement, paragraph 9 of Exhibit A, Your Honor.
I mean, does it define what good faith and fair dealing is, or just say good faith and fair dealing?
It says good faith and fair dealing, but I think there's a lot of contract law in this Commonwealth of Massachusetts that also talks about that.
So we're talking about a concrete case here. And I read with some care your brief to find out what future event it is that bars your client from liquidating the stock, or barred him when it was vested. And I read two things. One was some document in which I think it's paragraph 10 says there may be SEC rules. It doesn't say there is one. It doesn't say that on the date that he vested, he wasn't in an open window period, or that for whatever other reason he might have been allowed to do it. So there, unless I'm missing something, there's no evidence that he was actually barred by SEC rules at the moment of vesting. Your second possible future event is the board not approving it. And he says the board never approved it. I can see why someone might want board approval if they're the, I don't know if he was CEO, I don't remember what he was called at the time, and on the board. Obviously, well, not obviously, you do say that it might look bad for the company to have an insider sell. I think that's kind of phony, because I think in an earnings call you can say, as per his divorce agreement, he was required to liquidate this, and then people won't think that it's a reflection on, you know, the company. People have these plans where they, in a scheduled way, sell stock to diversify or whatever. But I don't see anything that says the board has to give its approval. So if there's no evidence that, and you'll correct me if I'm wrong, if there's no evidence the board has to approve, and there's no evidence that he's barred by SEC rules, why isn't that the end of at least this case?
I think there is evidence that the board has to approve. The separation agreement language itself talks about board approval.
If applicable.
If applicable.
He testified at trial and on cross-examination, which was over many hours, over multiple days, Your Honors. He was never cross-examined about that. The evidence in
He
the
doesn't
record,
have to be cross-examined about it. You need to put that in.
and I did put that in by asking him if he ever had board approval. And
You didn't ask him, it was board approval required before you liquidate this. That may have been deliberate, it may not, I have no idea. But you didn't ask him that. So
I-
of course there was no board approval. One reason might be not required.
I can quote from Appendix 12, page 177, where, Your Honor, it says in line 5, the question, and when, if ever, prior to that time, and this was the time of liquidation, did you have the consent of the Board of the Directors of AvroBio to liquidate your AvroBio stock options? Answer, line 8, I never had the consent of the board. I think that is crystal clear,
But the
Your
previous
Honors.
page, he says, it's understood that a CEO selling any material stock options is deemed a very negative event, and so that the board strongly discourages that. But that's quite different from saying the board prohibits it, right?
So the last part, Your Honor, was actually stricken by Judge Burchell. So it's only the first part that's in there, and that's his explanation of AvroBio and why this company, given its position as a small-cap biotech firm, would not be in favor of its CEO, its founder, and a member of the board of directors exercising his stock options.
But I guess it gets in, you were just trying to hook this up with the actual language of the agreement, and it says if no further event is needed, right?
Mm-hmm.
There has to be some kind of requirement that you can't liquidate. And of course, the husband doesn't have to liquidate at all, right? The husband can just pay cash or liquidate in part to pay the wife, right? Doesn't have to liquidate the entire holdings of stock options. But I guess the critical problem I have with your position is that I don't see what future event was needed at the time.
I would say, Your Honor, that Judge Burchell shared your view in that she specifically found in her rationale, her findings, and her judgment that no further event was not clear. That was the whole crux of the issue of there being ambiguity and her needing to clarify this agreement so that the wife could have, as I mentioned at the beginning.
If there's nothing that could be deemed a future event, just nothing, why does he have to or she have to clarify anything? Just say, I don't know what future event means, but there's no obstacle of any kind to the husband liquidating the shares. So in this case, we do it on the date of the vesting.
Because she wasn't just interested in having these parties settle the matter then. She was thinking long-term.
Yes, well, judges really should decide questions before them, don't you think?
I think she was deciding the question before her at the time, Your Honor, with all due respect, but I also think she wanted to, as she said in her judgment, thwart future litigation so that these people were not constantly in litigation. The evidence showed that they had been in litigation for some time. There was a lot of issues. As I mentioned, the judgment was 79 pages. There was a lot of litigation between these two. She wanted to clarify not only the issue before her, but set them off in a position where the wife had a definitive right to alimony. She used clear language about upon liquidation so that the husband would know when he had
Seems
to.
like the judge gave her a definitive right to no alimony.
I don't
Right?
agree, Your Honor. Otherwise, she wouldn't have written in that upon liquidation, she does have the absolute right to get alimony.
On liquidation, something totally within your client's control. So she has no right to alimony unless, for some reason, it might be strapped for cash, but for some reason, which seems unlikely, for some reason your client decides to liquidate.
Vesting would make no sense, Your Honor, for a variety of reasons, including one we haven't discussed, which is there could be no value. The
Then
stock-
nothing is added to compensation. Good point. If it's underwater, then there's nothing to talk about. It doesn't say it has to be a stock option that's, that he would want to liquidate. He can. He'd lose money to do it, so he's not going to.
And then she'd be entitled to zero alimony at that
Yeah,
point.
she'd get zero alimony.
But here, I think the judge was very clear. Let's put in when he liquidates. When he liquidates, she's going to have the certainty of getting money. And if Your Honors think she's playing games, or he's playing games, rather, then we go back
Isn't there a date after which she's no longer entitled to alimony?
Yes, Your Honor, 2033.
2033. So I don't know what year this was. When was the trial?
2024, Your Honor.
2024. So if he held on to these options for 9 years, assuming there's reason to think the company would be a going concern and blah, 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 if he held on to them for 9 years, he can liquidate them and keep all the money. You can imagine someone borrowing money at interest in order to preserve that right.
You could imagine a whole variety of scenarios, Your Honor, but I think with the scenario before the judge at the trial, she found that the best way to clarify this agreement was to put in the words liquidate.
But is that the intent of the parties? I mean, the intent of the parties says upon vesting, right? I mean, where in the record? I mean, I guess the other conditions are about liquidation, a liquidating event on the other things, but right? I mean, there's the private sale, that's a liquidation event, and the company going public, but I mean, so that's liquidation. But this one here is about vesting, but just vesting, not about liquidation.
So, Your Honor, I would respectfully disagree in that the word if comes up in that paragraph after vesting 3 times. And the word if in our dictionary is a conditional word. It signifies that the words after are going to modify the word before. In fact, Black's Law Dictionary defines the word if as a
I know what if means. You have to tell me.
But I think it's
So to find your client in contempt, I think the burden is on the other party to show clear and convincing evidence of a
Violation of a clear command.
a violation of a clear and unambiguous. I mean, I don't think that this clause is ambiguous. And the problem is a question of proof, though. Maybe the clear violation is what's ambiguous.
I would agree with you, Your Honor, in that there was no violation at all. The evidence showed that in August of 2023, a few weeks after he liquidated his stock options in May and June, and May 1st was when officially they announced that he was leaving AvroBio, he paid $68,000 and change to the wife as her 35% of those stock options. There was no cap, by the way, that was applied. The $1.4 million didn't come into effect. The evidence clearly showed in the findings that the wife got her $68,000. So this wasn't a case
Can
where...
I ask another question about this construction? And isn't this exactly the same as if the judge had read the contract to say there is always a future event. Right? You have to liquidate unless there's a future event, or we treat it as income unless there's a future event. Wouldn't you have to say there is always a future event? So we always go to the next clause and look at liquidation. So why isn't that reading future event completely out of the contract?
I think you bring up a good point, Your Honor, and this just circles back to the fact that the judge found an ambiguity.
Yes, an ambiguity is fine, right? But there must be something that's a future event. He didn't find that it was like a Scrivener's error or something.
No, in
or
fact,
she didn't find. She found that, right? So without saying there's some, well, there would be no future event if blank, but unless that's the case, it's always liquidation. The judge said, we're not even going to look at whether there's a future event anymore. That's not construing an ambiguous term, that's eliminating it, isn't it?
I think it's clarifying it, Your Honor.
Okay, what does it mean?
It means that instead of having these two parties try and figure out what's
No, I'm asking what the contract language means.
that
You said she clarified future
Yes,
event.
yes.
Under her reading, what does future event entail?
she doesn't put future event in there. She just says when
cuts
it's
it out.
liquefied, then you're getting your money. Then the wife would get her money, Your Honor.
Can I ask just about the valuation issue? So the husband sells in 2023 and she gets $68,000. Do you dispute that she would have gotten more if she had received the amount at the time of the vesting?
I can't dispute it, Your Honor, because as Your Honor's pointed out, that evidence is not in the appendix.
So there's no evidence as to valuation. So was there a representation made that it had been more? Or, I mean, what is the record as to, is there any record establishing that she lost money because of this?
I'm not aware of any, Your Honor. The
Okay.
judge was quite clear in her findings that she was entitled to the 35% of about $190,000.
The motion for contempt doesn't assert anything about this? I mean, why would someone pay their lawyer to go in and fight about something if it was a matter of indifference?
Because, Your Honor, he actually paid these monies in August of 2023. She filed for contempt in 2022.
And
So he didn't.
so when she filed, he had not paid her anything.
That's correct, Your Honor. He was still at Avrobio. He didn't leave till May 1st, and then shortly thereafter, he liquidated and paid her in August of 2023.
And the stock prices that the judge took judicial notice of, they're not in the record?
Not to my knowledge, Your Honors.
Can we take judicial notice of stock prices?
If it's not in the record, Your Honors, I'm not sure how you could.
You don't think we can take judicial notice of things?
I do think you can take judicial
But
notice.
isn't a stock price that's publicly available the kind of thing we can take judicial notice of? I mean, obviously, we can figure out what the price of the stock was on each of these dates. It would take 4 seconds, right?
Yes, but I think that still doesn't get you to the point of approval of the board, which is very clear in the record, as we spoke about, that he didn't have it.
Okay.
Thank you,
We
Your Honors.
understand your argument. Thank you both for excellent arguments.
Thank you, Your Honors,
Very
very
helpful
much.
to us. The case is submitted. The next matter we have will be number 25-926. This is Town of Brookline versus AFSCME. When you're ready, we will hear from you, Attorney Burwald.
Thank you so much. May it please the court, my name is Attorney Evan Burwald. I'm here for the American Federation of State, County, and Municipal Employees, Council 93, and we're here to discuss the Superior Court's stay of an arbitration regarding the termination of a civil service employee. There is a collective bargaining agreement at issue here, and there are 2 points that AFSCME would like to dialogue with this court about. The one being that the judge from the Superior Court has, in his decision, removed the right of just cause termination and the ability to challenge it before an arbitrator for all members covered by the contract. And the Superior Court has held that civil service employees do not have that right pursuant to the civil service laws under Chapter 31.
So this applies not just to civil service employees.
Yes,
there are
that
other
was the
employees under this in the collective bargaining agreement or unit who are not civil service employees and therefore would be left with literally no way to challenge the determination that there was just cause if we follow the judge's reading. Is that what you're saying?
That is what I'm saying. That is why we specifically asked the judge in the Superior Court to reconsider his decision, because there is there's language in his decision that is evident, that has been put in the brief, where if the court would give me a moment, where it is on page 44 of the brief, page 8 of the decision, where the judge holds that because the phrase just cause is located in the management rights article and because the rights afforded to management are not arbitrable, the judge said that, and the union has interpreted it to say, as long as the employer says they had just cause, it forecloses arbitration.
Well, wait, we're dealing with an actual employee here, right?
Correct.
And that actual employee is civil service protected, right?
That is correct.
And so you're saying, well, the logic of the decision might be applied to cover non-civil service protected employees in Brookline. Is that right?
That is correct. That's why we asked for reconsideration.
How many employees are subject to the CBA and not protected by civil service laws?
I don't have that number with you here. I believe most of our members there are not civil service, but I do not have a number for you, Your Honor.
Okay.
When was it, there's precious little information in the record about this employee. Do we know the hiring date of this employee? Because that seems to make a difference under Article 6.
Yeah, the hiring date of this employee, I believe that was, I apologize, Your Honors, I don't have the hiring date of this employee off the top of my head, but I believe this employee was hired after May of 2010.
After May of 2010?
I believe so, but there should be evidence in the record, at least talked about by Attorney Robert Van Kampen before the judge in Superior Court.
Parties understand and acknowledge that the civil service rules and regulations do not apply to any employees hired after May 21, 2010.
Then I apologize, Your Honors, I must be mistaken.
Must be before?
It must be before. I apologize, Your Honor.
Because it's clear that civil servants after May 21 go by under the CBA and not under the civil service rules?
2010.
2010, yes. I believe it says, I have it here, except as otherwise provided by Section 8 of the General Laws of 150E, an employee in the union shall recognize and adhere to civil service rules, et cetera, to another, or from one department to another for all employees hired on or before May 20th, 2010.
What happened in May 2010? Why is that? It's a very fundamental question, because I think you're right. Whatever we do in this case could apply to other people, but it seems like there's this very significant change that happened. And can you offer us any information?
I can't, and that's precisely why we believe this should go before an arbitrator, because an arbitrator has the power under the arbitration clause to take in that information, decide that information, and apply it. If you look at Article 22, or sorry, not 22, Article 20, Section A interpretation of the contract is considered to be a grievance. And that is what we are putting before an arbitrator.
Can I go back to this Article 7
Yes.
or Article 6 question? The parties understand and acknowledge that the civil service rules and regulations do not apply to any and all employees hired on or after May 21, 2010. May 21, 2010 is 16 years ago. I would have thought that your position and that the facts are that this person was hired after that date, because otherwise, what does this provision mean?
I apologize, Your Honor. The parties are in disagreement as to how, obviously, how this
About
provision applies,
about
but-
the hiring date?
No, not the hiring date, about the application of the provision. So the union's position is that the member and the union has an option. Because the employee is a civil service employee that has the...
Well, the ones hired before 2010 don't seem to have, well, I don't really know what it means. They shall recognize and adhere to all civil service rules and regulations relevant to discharges. Now, the rules and regulations, I mean, I don't really know what that means. They don't compel you to appeal to the Civil Service Commission. You could just accept your discharge or promotion or whatever, demotion, right?
Yes, you
So
could.
I don't understand what it means to adhere to all civil service rules and regulations. What is that? What's the difference between people hired before and after May 2010? There must be something.
To be honest, Your Honor, what with the arbitrations that we have supplied to the lower court and to yourselves are the most recent arbitrations for employees where that language would affect. We don't have the bargaining history from when that language was changed. The union does not have that information. The union has been operating with the town in the past of being able to arbitrate because...
Is this argued below at all, anything about this, Article 6?
Whatever was argued below, I was not present for that, was argued by Attorney Van Camp, and that's been provided in the transcripts.
But the town, in the town's application to stay arbitration, this is Record Appendix 12, Paragraph 15, they allege that the civil service laws surrounding discharges apply to the employee. So can we assume from that, I don't think you disputed that the employee was hired before May 2010?
Yes, that's why I apologized earlier, Your Honor. That is correct.
Oh, wait, so this Article 6, the first part about all rules and regulations of the Civil Service Commission applies to this civil service employee.
Yes, however, the operative sections under Chapter 131 are permissive.
I agree. There are cases in which people have chosen to do union grievance rather than appeal to the Civil Service Commission. And the SJC has never said anything like, what the heck is this, right?
The only instance I found, and I think it is also cited by the appellee, is a Town of Falmouth case where a contract did not have any just cause language, but the contract recognized the civil service statutes. Therefore, the member was foreclosed from arbitration because there was no just cause right under the contract.
Well, I found O'Brien versus New England Police Benevolent Association from 2013, and in that case, they don't rule on this question, but the person is doing a grievance, and they're a civil servant who had the option of going. But I'm trying to figure out now whether this paragraph, Article 6, maybe means that the union, bargained away the right for those employees because
I found the acts and resolves of 2010. This town of Brookline got out of civil service on May 2010, except for firefighters and police officers.
got out of?
Yeah.
How can you do
There are no civil service employees after 2010.
Okay.
You would have told us that.
Except for firefighters and police, is that right?
Right.
Okay.
But I do want to, as I just previously said, re-highlight that Town of Falmouth decision, where that collective bargaining agreement had no just cause language.
I'm not asking about that. I'm asking about whether the employee can use the grievance procedure at all if they're hired before 2010 and are a civil service employee. I'm trying to figure out what changed with respect to hiring. I understand they're not part of civil service anymore. You think even when they were part of civil service, they had a choice?
Yes, we found no record in our files that they were denied the ability to arbitrate before 2010.
Why would you have to put it in the agreement? Doesn't, as a matter of law, a civil service employee have the right to operate under the rules and regulations of the civil service? I mean, can you bargain that away?
Your Honor, I'm unaware. I'm going to make an assumption you can't, but what the collective bargaining agreement's purpose is to give another avenue.
No, I'm asking what the purpose of Article 6, first half of the paragraph is.
No, I understand.
What's the point of saying everyone hired before the state shall be subject to the rules and regulations? They already are, in some sense, if it gives them a choice.
Well, so
What could this mean other than
There's-
they don't get to grieve the just cause question if they're civil service employees? They have to go to the Civil Service Commission if they were hired before 2010.
I believe the Civil Service Commission also hears, it's not just discharges, it's also promotional opportunities,
Yes, but
appointment.
it lists discharges as one of the, if you look at Article 6, it lists it. I have no idea what it means, of course. I mean, there is someplace else where civil...
I mean, isn't Article 20 then?
Yeah,
You said it A. B says any other disputes, so you're saying it falls under A because just cause is a dispute under the bargain, under the CBA, and it doesn't fall under B. Any other disputes between employees and supervising arising out of administrative discretion, except those as will be properly under the jurisdiction of Civil Service Commission.
Oh, wow.
But that article, subsection B of Article 20, relates with the town bylaws. It doesn't relate to what a definition of a grievance is. And a definition of a grievance is a contract interpretation issue under Article 20, Section A. So there is a fundamental difference between the interpretation of Article 6. An interpretive difference is a grievance, and the grievance by the contract is arbitrable.
I don't understand. Getting back to Article 20,
Yes.
Section B, has this carve out, except those that would properly be under jurisdiction of the Civil Service Commission or other duly established appeal boards, right? That's the carve out for the general clause. Any disputes between employer and employees arriving out of exercise of administrative discretion is arbitrable. So why isn't, if we actually do have civil service protections for this employee, why isn't that a clear kind of statement that this subset of disputes is not subject to arbitration?
This subset of disputes also begs the question of what is an administrative decision, which we don't know because it is an undefined term in this contract.
Is it really that?
The union is of the position that it is because if a termination is an administrative decision, then the union doesn't have a right to go to arbitration. They are obligated to go before the human resources according to the bylaw. So what is an administrative decision?
Except it's under the jurisdiction of the Civil Service Commission.
Well, and I only have 2 minutes left, Your Honor. The judge's decision also impacts all members. It's not, civil service members, yes, and the member at issue is civil service. But again, as we brought up in our motion for reconsideration, we have serious concerns that the decision is more far-reaching.
What I'm trying to figure out is this. Even if we agree with you,
Yes.
this, in general, just cause has to be an arbitrable part of the agreement, or they could say people wearing gray pants are fired, right?
Yes.
And that's just cause, and there'd be no redress. So maybe that reading is wrong. But I'm saying, but why under Article 6 doesn't the union still lose if they've bargained away the right to go, for a civil service employee, to go to a grievance on this by saying they're subject to the rules of and regulations of the Civil Service Commission?
Because that is a grievance about the interpretation of the language of the contract, which is by definition a grievance.
You still haven't told me what someone hired before 2010 has to do that someone hired after 2010 doesn't have to do. So maybe you can tell me under Article 6 what the purpose is of drawing this line and saying these ones are subject to, these ones aren't. What does that mean?
The purpose is Article 6, you have another avenue if you don't want to grieve, or if you don't want to arbitrate. You can go to the Civil Service Commission instead of using Article 20.
And it's just up to the employees?
Up to the employee, and it's up to the union. Apologies for not getting to that point sooner, Your Honors.
So Section 6 begins with, except as otherwise provided by Section 8 of Chapter 15080. What does Section 8 of Chapter 15080 say?
Give me a second, Your Honor. So Chapter 8 of it's the binding arbitration statute that discusses collective bargaining agreements can have binding and final arbitration, and if there isn't specific language in a contract discussing it, the former Commonwealth Employment Relations Board can order arbitration. It also supersedes all other grievance procedures in law.
Is there something in there about the employee being able to elect arbitration?
Your Honor, I honestly don't have a recollection of that. Usually arbitration and grievance language and contracts are up to the union and/or the grievant themselves.
I understand your primary position, but do you have a secondary position here that, okay, in this case, maybe just cause is the way to read this CBA is that just cause is determined by the Civil Service Commission, and just cause is central to its work, right? And so for those employees, apparently like the employee here who has civil service protections, that is the way that issue gets resolved. But going forward, for employees that don't have civil service, union members who don't have civil service protections, that could be arbitrated because there's no other.
There is no other option for them.
Right.
That
So
is correct.
that would be your secondary position in this case, right?
Yes. All members have the right to arbitrate, especially those after 2010, May of 2010.
Your time has expired. Thank you very much.
Thank you, Your Honors.
We will hear next from, if I can find my sheet of paper, Attorney Friedland.
Yes. Thank you. Members of the panel, may it please the court, Barry Friedland on behalf of Appellee, the town of Brookline. Good morning.
Morning.
So the town requests that this court affirm the findings of the Superior Court and permanently stay the arbitration between the union and the town because civil service employees' terminations are not subject to arbitration under the CBA. It's not the town's position or reading of the Superior Court opinion that all ASME employees are not entitled to arbitration. We're only focused on civil service terminations and the employee in question.
Well, that's not what the judge said.
Here.
The judge, so you don't defend the judge's interpretation that just cause is within the management prerogative of the town. You don't agree with that.
We do agree with that, Your Honor.
All right. Also for non-civil service employees.
Correct, Your Honor.
All right. So now I'm a non-civil service employee.
Yes.
And my supervisor says to me, you know, you wear a suit every day to work. I prefer an environment that's a little more casual. You're fired. And the town says, well, that's just cause. That's it. That person doesn't have a Civil Service Commission appeal, obviously. They're not civil servant. And they can't arbitrate. That's not just cause. That's how you read this?
No, Your Honor. So in that case, if we look to Article 20, Section B, we would say that the supervisor's position to discharge for just cause is an exercise of their administrative discretion, but there's not that except for the Civil Service Commission's authority here. So that employee would be able to process their interpretation under the grievance procedure.
Wait, I don't understand what you're saying at all. They can ask the arbitrator, what does just cause mean? They say it means wearing a suit every day to work. I did my work, but I wore a suit. And the arbitrator can, in fact, say, no, that's not just cause. But you're saying for some reason it happens under Article 20. I don't understand.
Your Honor, I'm saying it happens under Article 20 because that is the grievance procedure. And here for the civil service,
The grievance procedure authorized by Section 31511 of the Human Resources Bylaw, is that grievance procedure in the record here?
it's just incorporated in this agreement here.
So I can't go read 31511 and go, oh, wow, look, there's lots of rights for the employee under here. Right? It'd be really nice if I could see it, or I could say, this doesn't give them any rights.
Sure, and
like Justice
Your Honor,
Rubin.
I do believe it's quoted in the Superior Court's opinion, if Your Honor would like to just read the bylaw. However, the procedure, just generally here, a step one grievance, again, it's here, they would put the form and they would have to mention what part of the CBA is up for interpretation. Then it goes to step two, which is a hearing before the HR board, which is what's mentioned here.
I don't understand how it's an act of discretion if it is also a management right. Among the management rights that are vested exclusively with the employer are the following: the right to hire, promote, transfer, the right for just cause to suspend, demote, or discharge. If your position is you get to decide who to discharge and why, because it says that, what does it matter what Article 20 says? I don't understand why, if it's your right, then it's exempted from everything else. It's a management right.
That's correct, Your Honor, that it is a right, and of course, it's exclusive to management, and it's reserved here in the CBA and obviously outside of the CBA as well. But if we read that article, it says such inherent management rights are not subject to arbitration and shall remain exclusively with the employer, except as they may be shared with the union by specific provisions of this agreement.
Okay, and what specific, and you say Article 20 is the specific provision.
Correct, Your Honor.
Did the judge say that?
That's not my understanding of the opinion, Your Honor.
That's not my understanding.
So, I'm a little dense, but like, make sure we're on the same page.
Sure.
I understand what you're saying now is that we have to read Article 2 and Article 20 and Article 6 all in conjunction, right?
Correct, Your Honor.
And if a union member has civil service protections, then those provisions mean that matters of discipline, the just cause can only be challenged via the Civil Service Commission process.
Correct, Your Honor.
But if they're not civil service protected, then the issue of just cause can go to arbitration and be determined by an arbitrator.
Correct,
Is that
Your Honor.
And
Wait,
let me
well,
just
go ahead,
finish
I'm
with-
sorry.
And so for all employees hired after 2010, except for firefighters and police, they can arbitrate disciplinary decisions.
Yes, Your Honor. And just a couple of clarifying points for the court that they were asking earlier. 240 employees in Brookline are under this ASME contract, and there are 12 employees that still enjoy civil service protections because they were hired prior to 2010 when Brookline laborers were still in the civil
This
service.
is in the record?
No, I was just answering your question from earlier.
Only 12 of 240?
Correct,
Okay,
Your Honor.
okay.
And the employee here is one of those 12?
He was while he was employed, yes, Your Honor. Well, it would have been 13 then.
Good for you. So there's, we have to look, but there's no statute that says civil service only. In fact, collective bargaining agreements can trump civil service, right?
No, Your Honor. Civil service are one of the statutes that cannot conflict and cannot conflict with the CBA. So civil service.
What is that under 150E, Section 7D?
Under E, correct, Your Honor.
Under E?
150,
Because, I mean, it's not one of the ones listed under D. Sections 41 to 45 of Chapter 31 are not listed under Section 7D of 150E.
just one moment, Your Honor.
You don't think it goes to an arbitrator anyway, right? You think it goes through the grievance procedure in Section 3.15 of the bylaws, right? Because you say it's under B.
Correct. Well, I would say, Your Honor, A, B, and C, that entire section is the grievance procedure. So it's step 1, step 2 in a 3 process, and it culminates in arbitration. So they would still go before
And the
HR.
arbitrator is chosen the same way they're chosen under the CBA or a different way?
Under the CBA.
The statute, I mean, the bylaw refers to the collective bargaining agreement.
I believe that the CBA references the bylaw, but the board that's created by the bylaw, if any step after that process would go to an arbitrator.
What do you say to their argument that
Can you
you're...
answer the question about 150E, Section 7D? She was looking for that.
Yeah, I'm
Oh, yeah,
sorry.
I'm so sorry.
May I, Your Honor, one moment? Thank you.
Because Section 150E, Section 7, Subpart D, lists a whole bunch of things that trumps collective bargaining agreements.
Correct, Your Honor.
But I don't see,
So we held in City of Fall River in 2000 that the civil service law is not one of the statutes identified in 150E 7D, which may be superseded by a collective bargaining agreement. But nevertheless, what happened in 2010 where Brookline essentially opts out of civil service? Is that it?
What happened? Yeah, they're just no longer in civil service, and like the police actually are no longer in civil service either as of last year.
Okay.
So yeah, it was just something that was bargained for. So again, but the employees that were already hired under civil service still will keep the protections that they had at that time.
Okay.
so the 12 remaining employees.
But you couldn't have a CBA that maintained civil service protections and yet somehow overrode those protections in part, right? That wouldn't be possible.
Correct.
You can't have an outright exclusion from the civil service
Right.
protections.
And in this case, like for instance, with this employee, the town, and there's no dispute that the town followed the civil service statutes by giving the required notice, the hearing, and all the steps that are required under the civil statutes, under the civil service statutes prior to terminating the employee.
Can I ask a question about your past practice?
You may, Your Honor.
So the union argues that you've been arbitrating these forever, or at least since, I don't remember what they say, 1996 or something. Does that have nothing to do with what the contract means, the way you've read it for the last long time?
So I have 2 points to that, Your Honor. First, and you can correct me if I'm wrong, just from the record, I thought that the union was referring to the non-civil service employees, and I do understand they provided evidence of some civil service, I think about 3, the last being over 10 years ago. And I would just ask the court, when looking for past practice, it's only for ambiguous terms, and I think the terms here are expressed that civil service employees are not entitled to arbitration. And again, that's if we're looking at the contract itself, if we're reading Article 20 in conjunction with Article 2 and Article 6. I believe that it's clear from the contract that civil service employees are not entitled to arbitration, but instead should seek review at the Civil Service Commission, which the employee in this case failed to do.
So it's clear that civil and service employees are not entitled to arbitration, and which provisions of the CBA make that clear?
Sure. So I think if the court first looks at Article 20, the grievance procedure, and again, reading that section B where it states, any other disputes between an employee and his supervisor arising out of an exercise of administrative discretion by such supervisors, except those that would properly be under jurisdiction of the Civil Service Commission. So in my reading of this, it wouldn't make sense to bargain for that language and include the language if civil service employees could go to arbitration under the agreement, rather than going to the Civil Service Commission.
Any other provisions?
Yes, Your Honor. Second would be Article 2, management rights, where the town exclusively reserves the right to terminate for just cause, a right that the article labels an inherent management right that is not subject to arbitration. And that's in the record appendix, page 29. And third, when we read Article 6 entitled Civil Service, which expressly recognizes that subject to limited exceptions that do not apply here, that the town and union shall recognize and adhere to all civil service rules, regulations relative to discharge.
Why do you say it's a discretionary decision? Right, so I'm the supervisor. Maybe I go and talk to town council or somebody. I say, I really want to fire this person. They're wearing a gray suit every day to work. And the town council says, well, you can fire for just cause, and if you find that offensive, then you can fire that person. That'll be the rule now. It's just cause. If anyone wears a gray suit, from now on, they get fired. Where's the discretion?
So, Your Honor, I'd say because the management right to discharge and terminate, suspend for just cause is reserved in the management rights, it's the manager's discretion in how to exercise that just cause. And again, the just cause is
It's not discretion, though. It's how to interpret the phrase just cause. That's a legal question, and you're saying we get to decide that legal question unless the person is a civil service employee and then they can appeal.
Well, I think at the inset, when they make the decision, the town does make that decision. However, it is reviewable either by the Civil Service Commission or by an arbitrator. So
It's only reviewable by an arbitrator, you say, if it's a discretionary act. If you say that you can't take drugs and work here, and someone does test positive for drugs, you fire them. It's not a discretionary act. You have a policy, that's just cause, and you just fire them. There's nothing to grieve or arbitrate, right? It's not arbitrary, it's just cause.
Right, Your Honor, I would agree. However, like in that circumstance, for example, it's possible that an employee could grieve because they disagree with the provision of the contract. So say it's in the contract, the no drug policy, something like that. They might have an argument on how.
No, it's nothing in the contract It's just cause. If you steal money from us, we're going to fire you. We think that's just cause.
Right.
And they say, oh, that's not just cause. They're done. There's no place to go.
So, correct, they would have to have some sort of issue with the interpretation of the contract.
The phrase just cause?
No, if they want to arbitrate why they were fired.
But it can't be because it isn't just cause.
Right.
I don't, okay.
Okay, and so just to conclude, I won't belabor my point much longer, but in this case, the employee was a civil service employee, and again, which is governed by the civil service statutes. It's not reviewable, and the parties have no agreement to submit it to an arbitrator. The union here should have sought review by the Civil Service Commission, and because the town cannot be required to submit to an arbitration a dispute that it has not agreed to do so, the town would just ask that the court affirm the Superior Court's opinion.
One more question.
Sure.
The Article 6, the introductory clause, except as otherwise provided by Section 8 of 150E, the employer shall recognize civil service rules. What is provided in, what does 150E Section 8 provide?
Your Honor, I thought that was where it said the civil service was a statute that could not be overlooked. I just couldn't find it right here in front of me.
I read that as saying that it can be overlooked.
Again, with my review of the case law, it's just my understanding that civil service statutes are ones that cannot conflict with the CBA and would cannot be overruled by a CBA.
There's some language here, I'm quoting out of context, where arbitration is elected by the employee as the method of grievance solution, that shall be the exclusive procedure for resolving any such grievance involving dismissal, notwithstanding any contrary provisions of sections 41 to 45 of 31.
Right.
So that you can be, that says, well, no, we don't have to look at the civil service thing because they can elect to.
So, and I do, is that case law you're quoting, Your Honor?
No, I'm quoting statute, 150E Section 8, which is incorporated in the agreement. But they might have not have argued that below, so we can't reverse on that ground. But
again, okay, thank you. And do you have something else, Your Honor?
no, thank you.
Okay, thank you.
Thank you very much. Very good, very helpful arguments from both of you. The case is submitted. We will next hear our third case. I should alert everyone that we will be taking our traditional mid-morning break after the next case, and so we will vanish for 10 to 15 minutes before we hear the final three cases. This is number 251039. It is Department of Children and Families versus Mother. It is an impounded case, so we will not use the actual names of anyone involved. Mother, father, and so on is what we should use. I gather the appellees are splitting their time. Is it 7.5, 7.5? Is that what I have here? Okay. And so with that, we will hear first from Attorney Krasner.
Good morning. I'm Sherry Krasner. May it please the court. I'm here this morning on behalf of Mother. My client is in Worcester, would have difficulty traveling to Boston, and was pleased to learn that argument is available on a live stream. When the trial judge allowed DCF's motion to prevent Mother from calling Dr. Maddox to testify or to have her report, a report that was commissioned by DCF, admitted into evidence, the judge stated on the record, if I messed up, the appeals court will tell me. I'm here to ask you to tell the judge that he did, in fact, mess up, and that his mistake constituted harmful error such that a remand is warranted. About 35 years ago, in custody of Tracy, a case about second-level hearsay, this court talked about steering as wide a course when it came to the admission of evidence in care and protection cases. The idea is that more is better in these cases. Evidentiary rules still apply, and process still matters, But because the stakes are so high, the court benefits from having as much credible evidence before it. Here, the judge had that opportunity, but he squandered it. The purpose of the rule in the pretrial order and the juvenile court rule about the admission of an expert and the expert testimony is to prevent surprise. So the other side can be prepared so that nobody is ambushed. People know what to expect when the trial happens. In this case, everybody knew about Dr. Maddox's report. DCF was the one who...
We're talking about a report from August of 2023?
Correct.
Okay. So there's no evidence that Dr. Maddox had any interaction with the mother after that date?
There is nothing in the record that suggests
okay. So
that.
And I mean, and that report, the evaluation was kept out of evidence too, right?
Yes.
And you didn't make an offer of proof, ask the judge to take it as for identification or anything like that?
Nothing.
So
the judge completely excluded it, and DCF kept objecting even when mention of the report happened.
So I mean, there are little mentions of the report throughout the exhibits, right? And as a result of it, the doctor identified a bunch of problems and said, and mother's not ready to take the kids.
Yes, you are correct that those little mentions came in. However, the judge in his motion, when he allowed the motion, it also excluded what was in the GAL report, and the GAL had sort of copied some of those recommendations.
The problem I'm having is this, and I think it's the same thing that Justice Massing just referred to. Let's say we agree with you that this is that rare case where failure to follow rules isn't within the discretion of the judge. It's a tough row to hoe, but let's say we found that. We'd still have to find prejudice. But you didn't offer the report for identification. You didn't make an offer of proof, Your Honor. If you let this in, it would say that she's the greatest person ever, and it's just a matter of weeks until, right? You didn't offer anything. How can we find it prejudicial? We have no idea what it says.
Well, I wasn't trial counsel, but...
I'm not blaming you, of course. I mean, trial counsel, basically conceded that she or he hadn't submitted the things on time and so on. But how can we find it prejudicial?
Right, because it wasn't just that the report didn't come in. What DCF wanted Mother to do, or what they said in their action plans, and this is in the record, is that Mother should then follow the recommendations of Dr. Maddox.
Okay, but that's about reasonable efforts or something. That's not about the fitness of the mother. And I just don't see how we can say, I mean, what would the point be of sending it back if we don't know it might make a difference?
Again, let me say something about reasonable efforts. So there was a problem in this case, as you know, is that Mother's trial counsel did come in pretty much at the last minute because of the illness of the first trial counsel, and perhaps a different trial counsel who wasn't ill would have raised a reasonable efforts argument earlier on. So that, I acknowledge that in a different scenario, that argument might have been raised. But again, DCF said, we want this mother, in order for this mother to improve her parental capacity, we want her to follow the recommendations made by Dr. Maddox. And then it comes to...
What are those recommendations?
The point is that DCF they thought that Mother...
And you say those recommendations weren't included in the action plan.
Correct.
How do we even know that? We don't have the report. We don't know what the recommendations
But we know it from the testimony that the two DCF social workers and a DCF...
But would they have made any difference? Right, let's say they were, and obviously they're not, this is fanciful, right, and foolish, but let's say they were, and be sure to eat vegetables and exercise because this will help you. And they didn't put that in the action plan. It would be pretty hard to say, if only they had done that and she'd known she had to eat the vegetables and do the exercise, she would have been fit. Do you see what I mean? It just comes down to prejudice for me.
I do, Your Honor, but let's step back and let's think about this mother. It is true that many of the parents who come before the courts in care and protection litigation have really tragic circumstances in their background. I think you all would agree that this mother's circumstances are particularly egregious, having been sexually molested by her father when she was 8 years old, not believed by her mother, shunned by her community for even bringing it up, pulled out of school in 5th grade, never having any more formal education. This was a mother who had an awful lot to learn about how to be an adult, how to be a parent, how to be a responsible parent. The fact that DCF brought in someone to evaluate her and to see what are her parental capacities, instead of just relying on some very, very young, inexperienced social workers, and that is the case here. Those 2 social workers were very new to the department, very new to the practice of social work. Bringing in an expert to look at this parent and say, understand her, understand that trauma history, make recommendations about how she could better perform as a parent, I think would be important in all cases, I believe, and particularly important in this case, given that parent's history. And for DCF, I mean, doesn't it raise a question in your heads, respectfully, that DCF was so intent on keeping this report out that there must have been something there that they, every time it was even mentioned, DCF counsel was up on his feet, saying, when Dr. Maddox's name was even mentioned, up on his feet saying, object, we object, the report wasn't offered. So I think for the judge that there had to be something there, and the judge's insistence that because the rules weren't followed to perfection, that we're just left with this question. And the stakes, it's not just, well, she can come back next week. This isn't like a modification case where you can come back and say, my circumstances have changed, there's new evidence. This is the end of the line. She lost her rights forever to parent her children. And I think that should create the way the judge elevated form over substance, that it should at least raise a question for this court that something was missing from this trial that could have been important to before making such a consequential decision. I also want to talk about the other, let me also say, and the mother in this case, despite that, did a lot of things. And the fact that the judge in conclusion 19 said that mother presented no evidence of her attempts to comply with her action plan, and that he said that she presented, in conclusion of law number 27, no effort to address her shortcomings. And I would suggest that neither of those conclusions have the proper evidentiary support. This was a mother who at the time of trial was living in a stable place, albeit a shelter, and I'll talk about that in a second, who was seeing a psychiatrist, who was seeing a therapist. She had signed limited releases so that the DCF could verify her attendance at therapy. She had applied for public benefits. She was in a domestic violence.
Excuse me.
She had taken domestic violence classes. There was no evidence of any current hospitalizations. Last hospitalization had been back in 2022. There was no evidence of any current domestic violence. So for the judge to have concluded that she made no effort or introduced no evidence certainly is contrary to what is in the record, even with the limited record I suggest that the
you're
judge
not-
had before him.
You're not arguing that she was fit at the time of the hearing. You're arguing that she was on the right road.
Correct. Saying that there was sufficient evidence that, insufficient evidence to irrevocably terminate her rights. And the record citations to those things I just mentioned are on page 35 and 36 of my brief, the specific references to the record, to those things she had accomplished. But yes, in answer to your question, the notion that this mother's rights should have been permanently terminated was insufficient. And again, even hamstrung by the fact that she hadn't been offered the services that might have gotten her farther down the road because the department failed to implement the recommendations of Dr. Maddox. The last point that I raised in my brief that I want to raise here today is about the judge's comment about the shelter, and his comment based on absolutely nothing in the record, that he wasn't comfortable sending the children to a shelter. And I just think, again, based on nothing other than something in the judge's own head about whether children should be reared in a shelter, is enough that this court should find that that statement on the record supported by nothing would be sufficient for this court to...
Does that comment by the judge make it into the written findings and conclusions?
Can I point to a specific finding? No, I cannot. But I think that comment made so early on just... It says something about how he views all clients that come before the court who have to take their children into a shelter is sufficient enough that this court should be bothered by it, sufficiently enough to vacate. It was based on nothing. There was no testimony about the conditions in the shelter.
Vacate and remand to a different judge?
Certainly, I think that would be appropriate.
The other parties raised there was no objection raised at trial. There was no motion to recuse or anything like that.
But that is correct. But again, I would say that the nature of it, and then he goes on, and this is page approximately 140 to 143 in that general area of the transcripts, where he talks about, well, why, because she was in a shelter just for women, but if she got the children back, then she would move to another shelter, and he...
Did she say shelter? I thought she said that she would get transitional assistance and move the kids into an apartment.
That was her ultimate plan, but there was, she talked about the fact that there were shelters for children, that mothers could have their children, and she would then apply for the transitional assistance.
I see.
And he suggests that she's somehow using the system in order to do that. And I just think those, what he's insinuating is just so inappropriate that this court should send a signal to the judges below, that mindset completely outside the record does not belong in these cases. I see I only have 9 seconds left, so if the court doesn't have any questions, I'll rest on my brief. Thank you.
I see no further questions. Thank you. We will hear next from, I guess, the department first, and it is Attorney Fairbairn.
Good morning, Your Honors. May it please the Court, Robert Fairbairn on behalf of the Department of Children and Families. Your Honors, the trial court properly concluded that mother's history of engaging in relationships marred by domestic violence, her failure to adequately...
Can you move the mic a little closer to you?
Her failure to adequately address her struggles with substances, including inhalants and alcohol, as well as her demonstrated inability to address her mental health, materially impacted her ability to parent her children, and that termination was in their best rights, in best interest, Your Honor. In reference to the conduct of the trial, mother was not prejudiced by the exclusion of the expert, and the expert was properly prevented from testifying. And also, Your Honor...
How do you know she wasn't prejudiced?
Because we don't know. 2 reasons, Your Honor, if I may address that right now. In terms of the trial court has broad discretion.
I didn't ask you that. I asked you how you know she wasn't prejudiced. I'm not saying it's an error. but not prejudice means we're assuming it's an error.
In finding of fact 120, Your Honor, 126, the trial judge notes, based on the limited references to the expert report, that mother reported that the expert reported that her history and past trauma had materially impacted her ability to parent her children, and at that time she was not fit to assume custody. So the most we have of this report, tangentially, is
That's exactly right. That's why we don't know if it's prejudicial or not.
So, Your Honor, I would suggest the only information we do have, but
You didn't put it in. It's your report.
so, Your Honor, I'd say two things to that. One, the department is entitled to determine what evidence.
I'm not interested in, like, is it okay? I'm just saying, as a matter of fact, you hired this person, they did a parental evaluation, a zillion things came into the record, but you did not put this in, presumably deliberately.
Correct, Your Honor.
So maybe it is prejudicial. I have no idea.
And I think that's the issue, Your Honor, because the standard is whether the judge abused his discretion by disallowing this expert. So absent any evidence, it could have been prejudicial. And there could have been multiple ways in which we could have determined what was in that report. There could have been an offer of proof. There could have been, even post-trial, there could have been a 60B motion in which they require an affidavit from the provider saying, this is what my evaluation was, this is what I would have testified to, this is what my findings would have been. And that is absent. And because of that absence, Your Honor, I don't think we can presume prejudice. I think all we can rely upon is whether the trial court adequately used his discretion to exclude this report from coming into the record.
Have you seen the report?
I have not seen the report, Your Honor. It was contained in the report itself, the substance of the report. I think it was in both of the court investigations. I believe it was recited in full in those, and they were struck from the court investigation through the department's motion to eliminate.
All counsel below had seen it, right?
All counsel below had seen it. It had been reproduced twice several months before trial. And in reference to mother's trial counsel, it is correct she's a successor counsel. However, she came on board in July of 2024, and the pretrial was until August of 2024. I believe it would have been about 40 some odd days. And she was provided the record, and in that record, in both court investigations, were the GAL reports. So I think that speaks to sort of the issue here is, I think at some point everyone's relying on the department knew they're the ones that provided the report, but we don't know what that expert would testify to a year and a half later. And also, Your Honor, there was no curriculum vitae provided, and there was no summary of what the testimony would be or what her capacity would be. And I think relying on common knowledge when it's an expert witness, I think would be materially unfair, and it was within the judge's sound discretion to exclude that expert. In reference to bias, Your Honor, if I may touch upon that briefly.
Just before we just leave that, why shouldn't we be concerned that the department tried so hard to keep the evaluation out?
I don't think the court should be concerned by that, Your Honor. I think the department was focusing on the mother's current parenting capacity as it was at that time. And as there had been no, insofar as it may have impacted reasonable efforts, I want to say two things on that. The first is that over the life of the case, there was not one single abuse of discretion or Rashida motion brought. So the issue of reasonable efforts wasn't brought before the court in a timely manner by the time of trial. And secondly, even if the court were to find the department's efforts were not reasonable, that does not preclude the trial judge from terminating parental rights and finding that mother, no matter what happened, that she had failed to adequately address the issue. So I would say that we'd be speculating, and that even it would not materially have impacted the case, and most especially the department's case.
Hard to say.
It is hard to say, Your Honor, I agree. But again, I think the judge was properly declined to engage in speculation as to what the nature of that was, especially since there was 7 months to cure the defect.
He did then, though, continue the trial for 2 more months.
Correct. And over those 2 months...
And it's not like you didn't know who this person was or where to find them or what they said. They're your expert, actually.
Absolutely correct, Your Honor. They are our expert. They were someone employed by the department. But it is incumbent on mother's counsel, if she wished to bring him in as an expert,
Well, I don't think a lawsuit for malpractice is going to help at this point. What do you think?
No, I don't think so, Your Honor. But I think the problem is, even though there was a delay in trial from January until March, During that time, Mother's Counsel still could have rectified the defects in January, submitted a CV and a summary of proposed testimony. And I think perhaps then that might have been a stronger argument. But at that point, Your Honor, I think it was too late.
What's the basis for the judge's conclusion that the mother was using the children in order to get an apartment rather than the other way around?
So, Your Honor, the judge's comment, I think, has to be viewed in context in the transcript. He makes the statement, although it may have been somewhat regrettable in his phrasing, that was information he gleaned from the trial. And if we look at the transcript in its entirety and early on in his questioning, he points out he has concerns about Mother's current housing. He kept saying, this is your trial, this is where you are now. I think that statement, although it may be regrettable in the way it is phrased, viewed in the context of his questioning about her housing and her...
Some people use their children, apparently, to get governmental benefits. Certainly that's alleged to happen. He seemed to be saying, and that's what you're doing. It's not that you want the kids and are going to find a way for them to have a house that isn't a shelter. It's that you want to not live in a shelter and you want the kids so that you can get DTA support for an apartment. What is the basis for that? That seems like a pretty strong allegation. I mean, among other things, if a person did that, they would be an unfit parent.
Yes. I do think it is a strong statement, Your Honor, but I think if we looked at the fact that at the time the statement was made, it was made very early on the first day. There was never a motion to recuse, and I think the case law suggests that in the context in which it was viewed at the time by trial counsel, it was not viewed as prejudicial.
Let me ask you this. You can't get this housing, we've seen this a lot, until you have the kids in your custody. I'm not the person who wrote those rules. They seem backwards in a way, or at least you should be able to have some preliminary evaluation or something where you can say, like, all I have to do is X. So everyone who's in a shelter who gets custody of their kids has to stay in a shelter until they're approved for an apartment, if they ever are. I understand, who knows, right? So when the judge says, I am not going to put kids in a shelter, isn't he essentially saying I'm never giving children to someone who is in a shelter?
I don't believe so, Your Honor.
Huh? Okay.
As I'm going to suggest that if the judge had been presiding over this case, and over the 4 years of the case, Mother has had chronic housing instability and has prioritized unsafe placements and declined all assistance provided by the department, all shelter references, she had declined it until September of 2024, 4 or 5 months before the trial. In fact, she chose to live in an environment with a very dangerous sex.
And if he'd said, I'm not giving a child to someone who has chosen such unsafe housing, that would be one thing.
Yes.
But what he said was, I'm not going to give children to a custodian who's going to take them to a shelter.
Even if we were to take that at face value, Your Honor, if we look at the judge's findings, housing is one of the many constellation of factors he looks at, and the fact that she was in a shelter does not factor into either his reasoning or his findings.
Just into his thinking, right?
I think, Your Honor, it was an unfortunate choice of words.
Or an unfortunate thought. I see no more questions. We will hear now from Attorney Matsika.
Thank you, Your Honors.
May it please the court, Valerie Matsika on behalf of the appellee children. I last saw my clients last week. They are currently 5 and 6 years old, and they are in the same placement where they have been for the last 5 years.
And that remains a pre-adoptive resource.
That's correct, Justice Rubin. Members of the panel, the children are home. They are with family. The grandparents' home is the only home the children have ever known, and they're asking this court to affirm the ruling of the trial court below. And that's because Mother lacks the capacity to parent. Mother has a significant history of trauma that impacts her baseline functioning. She has a long history of mental illness, and in this case, it includes hospitalizations, both voluntary and involuntary, and it includes suicide attempts. She's been involved in violent relationships for near 5 years in front of the time she was in front of the trial court. She's been homeless for approximately 4 years in the time she was in front of the trial court. There's a history of substance abuse, and while all of that is happening, the children are bonding to the grandparents. Just to briefly address mother's hospitalizations and suicide attempts, they began in September of 2021 when mom crashed her car into a telephone pole, got combative with responders, and told the police she was trying to kill herself. And they took her to Haywood Hospital. All through October of 2021, there were both voluntary and involuntary hospitalizations for suicidal ideation. And then in November 11th of 2021, while she's driving her car, she gets pulled over by a police officer for erratic driving. She's got nitrous cartridges filling up the car, and she's lighting a cartridge in front of the police officer who asks her to stop. He doesn't think it's a good idea for her to use those drugs in front of him, and she says to him, "I can't." At that point, again, he transports her to Haywood Hospital for treatment, and these ideas of self-harm continue into 2022 when she reports to father that she's still thinking about hurting herself. And indeed, several providers told the trial court that mom is not ready to parent. Mom's therapist in March of 2023 said mom is not ready to parent. The evaluation also concluded that mom is not ready to parent. Mom continuously engaged in violent relationships while she was in the microscope of the trial court, Your Honors. In July 2019, father choked and slammed her against a wall. In March, he ripped her hair and bruised her, and the child was in the room and was injured in that foray. Interestingly, then in June of 2021, mom begins to do domestic violence courses. Did they work? No. Because then in July of 2021, father strangled mother and another person and was arrested. Later that month, mom said to the department, "You know, I'm still working on my relationship with father." In September of 2021, just a little bit later after those domestic violence courses, she shatters father's window with a weed whacker. She didn't learn much from the domestic violence courses. The violence continued, and mom, even after father got a restraining order on mother for breaking his window and attacking his home, she continues to contact him way into October of 2023. Bad relationship. Maybe it was a one-time thing. No. Then mom begins a relationship with one of Gardner's high-risk domestic violence offenders. That starts in March of 2024, and then when she's visiting the children, she's got a black eye, she's got crutches, she's got a burn on her leg. And then we focus on June 4th, where Mr. C slaps her with objects and hits her. She turns around the next day and modifies that restraining order so Mr. C can come back into the home and have contact with her. Was that a bad idea? Yes, it was, because on June 6th, when she had a visit with the children, she arrived to that visit limping. Mom could not make this leap from what she learned in these services to what was happening in her world. She abused substances. The court has already heard about some of the substance abuse, but that's the reason the case came in. That's the reason the trial court matter began. The department was working with mother, and they were trying to help father and mother. But then they made a plan, a safety plan. Keep those kids away from father. Easy, no problem. 5 days later, mom goes with one of the children to father's home. She was nursing the baby with a blood alcohol level of 0.166. She didn't know where her daughter was. So there was an all-night foray of calls to try and figure it out. Termination in this case is in the best interest because the children are bonded with their grandparents. A bonding expert did testify at trial, and she said it would be very damaging to the children if they're removed. She also said it would be catastrophic to their well-being and their ability to form healthy relationships with others. That the court relied on that evidence. I know much has been discussed about the report and the exclusion of evidence, but on these facts, this is not a closed case. On these facts, even if the judge was too strict in his exclusion of the expert and the report. It doesn't matter because there are so many factors, a constellation of factors that show that mother was unfit. Even if the report had been admitted, the parenting report says mom can't parent. That's the crux of the report, the resolution of the report. Just as
And we know that from?
We know that from finding 126, and it's Exhibit 19, and it's one of the exhibits that the motion in limine was not struck by the motion in limine, and it's just a very short blurb from the parenting expert. Exhibits Volume 1, page 97. It's a DCF report dated 3/8/24. And the report says, mom's adverse childhood experience, this is Dr. Maddox's report that someone else is just kind of summarizing. And it says that the adverse childhood experiences have impacted her emotionally, as well as her use of substances, as well as her mental health issues, and the results indicate that mom is just not ready to parent. Because there was no Rule 60B motion and no offer of proof, as Justice Massing has said, we don't know what other things the report could have said, but any exclusion is harmless error on the part of the judge. There is a significant history of trauma here, Your Honors. Your Honors, I see my time is concluded. I thank this court, and on appeal, none of the findings are contested, and for those reasons, these children respectfully ask that you uphold the decree, and I will rest on my brief.
Thank you very much. I see no further questions. Thank you all. These are very difficult cases, of course, and counsel's assistance is very much appreciated. We are going to take our traditional mid-morning break. We will return in 10 to 15 minutes to hear the remaining cases. morning again. So, we have now 3 cases that we describe as paired, but of course you can only pair 2 cases, but there are 3. They are not technically consolidated, so technically each one could have its own 30-minute argument. On the other hand, except I think for the question of each plaintiff's, the sufficiency of the evidence for each different plaintiff, I think the basic arguments are the same. So, and you can say like, no, I want to do this for an hour and a half, and we will. My suggestion is that we do something like 20 minutes aside so that you can put in whatever bells and whistles go with each of the 3 people, and we will be flexible if we get to the 20 minutes and you're still not done, we'll go a few minutes over that. Does that sound all right to both of you? I see that you are both nodding, so that's what we're going to do. So I will call them all as a group. Now, it's tricky because these are impounded cases, so we're not allowed to use the actual names of the people, even though you're one of the people. So I think what we will do is, so the 3 cases are 25-9-17 JN versus KN, 25-9-21 DN versus, I think it's actually, oh no, they can't, DN versus KN, yes, and 25-9-18 K-N-O versus KN. And so I think it might be easiest to just use things like father, sister, brother. And I guess we could say defendant or appellant, whatever seems better to you. And I should also say, since you will be, in fact, arguing first, we know you're not a lawyer. And I'm sure it is very difficult for pro se litigants because they're not familiar with courtrooms, there are a bunch of judges sitting in front of them and all of that. So we're going to try to be as nice as we can be and, grant you a little leeway. And we're not, we want to hear what you have to say. That's our job. So with that, we will now hear from the appellant.
Good morning. I am K.N., the appellant in cases 2025 P-0917, 0918, and 0921. My argument today is legal and procedural. These cases were moved away from 209A on April 10th. They were still on the 258E track on April 24th, and then they were moved back to 209A during DN's testimony on May 12th. The cases were heard on one track and decided on another. That's the core error that I'd like to try to expand on a little. On April 10th, my family members came in seeking 209 orders. The court reviewed the actual allegations and affidavits, and Judge DeCoupa did not treat family relationship as enough. He asked the abuse questions. K.N.O., my sister, answered no to physical violence and no to threatened physical violence. J.N. just said, same as my daughter. D.N., my brother, said there had been no physical harm and no physical threat. The judge said he was coming up empty on 209A abuse. He said the contact was bordering on more of a harassing nature, and he moved the cases to 258E that day of the ex parte hearing with instructions specifically to use the same affidavits when they moved them from the 209 that he rejected to the 258s he moved them to. That was a clean switch. Same papers, different statutory track. That ruling matters because family relationship made 209A available. It did not prove 209A abuse. It kept the focus on the statutory abuse, not relationships alone. On April 24th, cases were still on that 258 track. The full hearing did not even happen that day because I had to ask for a continuance. DN's testimony, my brother, had already begun, and when we broke for the continuance, the court said the resumed hearing would start with DN on May 12th. That did not happen. May 12th did not simply finish that 258 hearing. During DN's testimony, the court raised the 209A indifference standard. The court moved the cases back to 209A mid-258 hearing that morning of May 12th. At that moment, the operative written record was still the existing 258 track material from the same affidavits Judge DeCoupa had already found insufficient for 209A on April 10th. The court did not first identify a new 209A packet, did not first confirm service, did not first confirm exhibits and attachments, it did not first give review time. The court changed the statute first and only then allowed the appellees to refile during the recess. On April 10th, there had been an express same paper approach. The same affidavits were used when the cases were moved from 209 to 258. On May 12th, there was no matching same paper instruction. Instead, appellees submitted new or material different 209A documents during this recess. The parties had been told to return at 2 p.m. on May 12th, but the hearing didn't resume until about 3:30 that afternoon. Even then, the court did not identify the new packets, confirm service, confirm exhibits or attachments, or give me time to review. That creates a problem. If the May 12th papers were the same papers, then the April 10th insufficiency remained. If the May 12th papers were new or materially different, then service and review were required. If the record cannot tell which papers were operative, that uncertainty is a problem. I was not properly served with the refiled 209A packets before that hearing resumed. I was not provided new complaints, affidavits, exhibits, or attachments before testimony that started a brand-new statute in case.
Am I right that you had a lawyer by that point?
Yes.
Because the lawyer, correct me if I'm wrong, the lawyer didn't object.
Correct, Your Honor.
Okay.
And one more, and your lawyer, in fact, on your behalf, filed 209As against the three of them too, right?
I originally filed reciprocal 258s when I received them on April 10th and was served at my home. When the cases were switched to 209A mid-hearing, I refiled my 258s under 209s, but I followed the same paper track and used the exact same affidavits and documents that were part of my 258. Not brand-new documents to cater to a 209.
So the biggest problem you're identifying is is the switch of the supporting papers that you didn't have an opportunity.
That is one of the core issues today. Yes, Your Honor. Okay. Yeah, the court did not confirm what exhibits were included. It did not confirm that I had the full materials. It did not give me time to review them. A same-day served-in-court notation cannot answer the real issue. Service needed to happen before the converted hearing resumed. It needed to include the operative packet. Service after adjudication cannot provide notice before adjudication. Frazato, COVMM, and Eardris confirmed that protective order hearings can be fast but not fairness-free. Once the court changed the statute mid-hearing and allowed new 209A filings, I needed to know the case I was required to answer. That mattered especially because these were communication-driven cases. They turned on text, emails, message volume, selected phrases, tone, and interpretation. In a communications-driven case, context is the defense. The defense was not simply, I denied sending these messages. The defense was that selected messages were being interpreted without a full communication timeline. Context meant who contacted whom, who reinitiated contact, what triggered that next message, whether selected excerpts changed meaning when read with the surrounding communications, whether the communication history was one way or mixed, whether one petitioner's facts were being used to carry another petitioner's orders that day. The communication timelines were also different for each petitioner. K.N.O's November email chain followed a card that she had sent me where I had already told her to no longer contact me. J.N., my father's, became involved later, and D.N., my brother's April communications were much later in this timeline between the three family members. Treating all three as one uniform communication pattern blurred petitioner-specific proof that day. The court itself recognized that contacts mattered in certain instances. On April 10th, this ammo language was treated as figurative, not literal, by Judge DeCoupa. On May 12th, the court corrected this day of reckoning phrase as legal process language taken out of context. And DN, my brother, even said during his own testimony to questions, without context, nothing makes sense. That's exactly the point. My defense binder was not a random extra set of papers that day either. It was a timeline and context defense. It was meant to show selected excerpt problems, contact history contradictions, and the surrounding communications. Only 2 defense exhibits were admitted, even though the case against me depended heavily on selected communications. I had another 8 exhibits that day. The second major point is petitioner-specific proof. These cases shared a process problem, but the proof was not interchangeable. JN's case was not K.N.O's case. K.N.O's case was not DN's case, and DN's phrases could not carry the other 2 dockets that day. On 0917, JN had to prove JN's own case. On April 10th, JN did not present a physical abuse case. He said no physical harm. When asked about threats, he gave a derivative answer, same as my daughter. That was not JN specific. It was also tied back to K.N.O., whose answer had been no physical violence and no threatened violence. The concrete threat from JN on April 10th identified was litigation. The original packet was about communications, calls, emails, a state conflict, and family dispute context. The later 209A presentation moved into physical harm framing and selected excerpts. This chokehold by my father or neck grab allegation was not visible in the written 258 or 209A packets. It surfaced only in testimony after the case had had moved from 258 to 209. I dispute that it happened, period. Even as that allegation came in, it was late emerging, testimony only, undated, lacked developed context, and it was narrowed on cross by my attorney that day. That allegation shouldn't be treated as proof that, the April 10th defect is still in effect.
The allegation you're talking about is, I missed what you said, is it the headlock allegation?
Yes. If it was going to be part of the 209 case, it should have been in the operative written papers and tested through a clean 209A process that day. Instead, it lacked clean foundation in the operative papers. It showed why packet identification and review time mattered. In 0918, K.N.O., my sister's case, she had to prove her own case. And her packet change is the clearest packet change in these dockets that you'd probably noticed. On April 10th, there was no physical violence or physical threat showing from K.N.O. She answered no to both. The court moved the related matters to 258 because 209A showing was lacking. The later 209A packet added physical harm framing in the largest exhibit set. That wasn't just a label change, it changed how I had to answer that case. That matters because the post-hearing papers I received did not include those affidavits, exhibits, or attachments. The transcript does not show that the court identified that operative new packet from K.N.O. They never confirmed what exhibits were included. never confirmed service, never gave review time before the hearing resumed. K.N.O's contact history also mattered. Her affidavit says she internally decided after October 2023 that she did not want further contact, but the record does not identify a clear message where she communicated that boundary to me, and then she later reached out through cards, including after I had asked not to be contacted. That's what initiated the November email chain that followed. That does not prove the whole case by itself, but it shows why context mattered. The communication history was not one way in the simple way the appellees presented it. In 0921, DN, my brother, they may try to position that as the case that sounded the strongest. They may point to selected phrases like walk down the ring, test me, you will pay, I'm not going anywhere, or gonna, spelled G-U-N-A. Those phrases do not prove physical threats by themselves. On April 10th, DN said there was no actual physical harm. When asked about physical threats, he answered, not directly. If the theory was an indirect physical threat, the court needed to identify the exact words supposedly creating that threat and why that interpretation was reasonable.
Now, you understand that with lots of this evidence, leaving aside the procedural problems, which we understand, that with lots of this evidence, and maybe this is a kind of problem with courts generally, or an issue with courts generally anyway, I don't know if it's a problem, the judge gets to figure out what he or she believes, what they think something ambiguous might mean, things like that. So a lot of what you're saying, I mean, I understand your argument, but a lot of these things, take even the headlock example, if the judge heard that and believed it was true, then, right, the judge has more information that might point toward a need for an order than if the judge didn't believe it. And we can't change what the judge believed because we didn't hear the testimony to figure out what to believe. So just so you understand how limited our review of some of that stuff is, again, leaving aside these, the initial procedural irregularities.
I understand.
Okay, yeah.
There's some subjectiveness to the.
Yeah, and that's, I mean, that's why we have trial judges, and they obviously have a lot of power because of that.
Understood.
Yeah.
I do. I follow, Your Honor. Thank you. Then, you know, if that is the case, then I would hope some of the things that were presented, for example, how DN, my brother's contact history, also shifted that day. On May 12th, it moved backward from before 2023 and then to 2019 or earlier, yet one of the exhibits I did have the ability to commit into evidence showed a September 2023 sibling communication amongst the three of us. So, you know, does that make someone go, oh, well, he didn't tell the truth about when this last communication was? I hope that has some subjective effect on that day as well for the judge. Or that it undercuts the clean one-way, long severed contact history narrative that he was presenting that day under testimony. That case was just not as clean as the appellees presented it that day. Each petitioner needed petitioner-specific proof. I expect the appellees to say this was one family situation. My answer is that its shared family background does not replace petitioner-specific proof. I expect appellees to say family relationship made 209A proper. My answer is that relationship made 209 available. It did not prove abuse. I expect the appellees to also say I filed those reciprocal 209 complaints. As I explained, you know, I followed the same paperwork track there. I expect them to say I had counsel. My answer is that counsel's presence did not create advance notice, did not identify the operative packet, did not establish full packet service, and did not give me review time before testimony resumed that day. I expect the appellees to say no continuance was requested. My answer is that continuance request was not what creates the right to a fair reset. Once the court changed the statute and allowed refiling during the recess, the court should have stopped and made sure the process was fair that day. I expect appellees to say protective order hearings are informal. My answer is that informal is not fairness-free. I expect the appellees to rely on coercive control. My answer is that coercive control is a real 209 theory, but it is a defined statutory theory, not a catch-all label. If these cases became coercive control cases during the May 12th hearing, that made notice, theory clarity, packet identification, and review time more important.
Did the judge not say whether it was coercive control or reasonable fear of imminent serious physical harm?
It was very hard to follow that for my trying to interpret all that was going on in that short period of time where things flipped from the 258 track to the 209. You got to remember, we were in the middle of my brother's second testimony that was carrying over from the mid-hearing or the second hearing that we had on April 24th. So it was hard to follow exactly what the judge was pointing to for how he determined the same things differently than Judge DeCoupa did that day on the ex parte hearing where he said 209A didn't fit, to then say, oh no, it fits. So I'm not sure. Expect the appellees to rely on communication cases like Noel and Constance. My answer is that communications can matter. I'm not arguing that otherwise. But Noel and Constance do not remove context, objective proof, petitioner-specific proof, or fair process. The court does not have to minimize anyone's concerns to reverse this. And I'm not asking the court to approve the tone of every message. The question is narrower. Were these 209 orders entered through a fair 209A process on a clear operative record with petitioner-specific proof? They were clearly not. On April 10th, the court made a clean switch away from 209A using the same affidavits, finding the 209 showing lacking. On April 24th, the cases were still on that 258 track, and the full hearing had not happened. On May 12th, the court made an unclean switch back to 209A during DN's testimony. Same papers means the April 10th insufficiency remained and had to be explained. Change papers means service, packet information, exhibits, and attachments in review time are required. And unclear records means the uncertainty is itself the problem. I ask the court to vacate the orders. If the court reaches insufficiency, vacature should end these matters. If the court decides only the process issue, the fallback is vacature and remand for separate, properly noticed 209 hearings. Thank you.
Okay, you feel like you've said what you, I mean, I think we understand your arguments. But
Yeah, and I can jump into questions. Thank you so much for letting me kind of
course.
put everything out there.
No?
Very good.
No? All right, your time has expired. We will hear now from Attorney Guerra.
Thank you, Your Honors. Good morning, and may it please the Court. My name is Kelly Guerra, and I represent the plaintiff appellees K.N., D.N., and K.N.O., D.N., and J.N. I ask that you affirm the trial court's orders in issuing the 209A orders because the defendant has not met his burden today in showing that there is an error of law or that the trial court abused his discretion. So I do see, essentially three silos of issues. There is the procedural deficiencies that the defendant alleges, the sufficiency of the evidence per plaintiff, and then an ADA claim. So first, looking to the procedural deficiencies, I would argue that it was not procedurally deficient. The Supreme Judicial Court, as well as the legislature, has recognized the fluidity of these types of hearings, that it is meant for a layperson to come in, and that it's not supposed to be conducted under very strict rules.
Well, you say these kinds of cases. Do you mean 258E ones or 209A ones? I mean, there are statutory requirements under 209A for bringing a case. Now, I do note, as I said to the appellant, the lawyer didn't object, and that seems like a big problem. But I don't know that these were procedurally. This is a procedurally proper way to proceed. The standards are different in 258E and 209A. So
the standards are different, Your Honor, but I would argue that the circumstances surrounding the hearings that day indicate that the defendant was well prepared to go forward on a 209A hearing. So first, I would point to the fact that his defendant made multiple mentions of the 209A standard. In fact, they had filed what I would argue retaliatory 209A filings against the plaintiffs, and in doing so, the defendant's attorney was able to say to the judge, well, I'm doing it under coercive control. He indicated—
Do you think your success was under coercive control or under reasonable fear of imminent serious physical harm?
Based on the court's findings of a threatening nature of the messages, I believe that that's a finding under the fear of imminent harm. However, the court did indicate at some point during the hearing, I unfortunately don't have the pin site off the top of my head, he does indicate that when he read those messages, he reads coercive control. But I think the threatening nature of the messages goes more towards the imminent harm, which is what I mostly briefed in my brief.
So tell me about K.N.O.
Gladly, Your Honor.
Tell me what evidence supports the finding. And also, I have a question about standard of review.
Sure.
Are we being asked to conclude, as a matter of law, this was not sufficient? I guess that must be what we're being asked to conclude. We're not being asked to say, within the judge's discretion, could the judge have found this, right? It's a purely legal question. Is that right?
Well, there is the utmost deference that is applied to a judge's findings at a hearing like
Factual
this.
findings.
Correct, correct. But I would, and it also goes to credibility of the plaintiffs and of the evidence that's presented to them.
But the legal question, is this sufficient to demonstrate by a preponderance of the evidence that reasonable fear of imminent physical harm? That's a legal question, and even what's reasonable fear is a legal question, right?
It is a legal question, Your Honor, but it is very much informed, well, it's at least partially informed by the demeanor of the parties that day. I would suggest that very little weight should be granted to whatever happened at a prior 258A or 258E hearing, because that matter is not before this court, and it was not the same trial judge that heard the evidence that was heard on May 12th. But what's specifically different about those two instances is that the trial court on May 12th had the opportunity to observe both parties, which under IMLE is something that is relevant. How are these parties presented?
Well, if the evidence is sufficient. So tell me what evidence gives you fear of imminent serious physical harm and why that's reasonable.
Certainly, Your Honor. So,
And do K.N.O. first, because I think that's probably the weakest of the cases.
Understood. So looking at Record Appendix 4, page 66, the plaintiff testified that the defendant is increasingly angry, agitated, intimidating, paranoid, and especially in April 2025. He had told the plaintiff, "You may not see me coming, that your day of reckoning is coming, you're going to pay." And that was the line where the trial court pressed the plaintiff, didn't he mean legally? And the plaintiff did concede that, yes, she understood that it meant legally.
So how is a threat of legal action give someone fear of imminent serious physical harm?
Well, Your Honor, serious physical harm or threats of physical harm are not actually required to find that there's a fear of imminent harm. And for that, we can rely on Constance C., Noel N.
Okay, but if I say to you, like, I'm going to crush you in court because I have such good evidence, that's not shouldn't put you, I think, in fear of physical harm.
Not physical harm, although I do believe that does go to the prong of coercive control, though, it's not clear.
I don't really see coercive control here. It just doesn't seem, don't we need a pattern or something of coercive?
Yes,
I mean,
I would indicate that multiple messages over the course of a year, but especially within a few days prior to the filing, is a pattern of conduct, especially where there's very clearly
we don't have enough information to know what control this someone's brother who doesn't live with them really has over their, whatever their life or, right? It just doesn't seem, maybe I'm wrong. I mean, it is a new part of the statute, and I can't say I understand it completely, but.
Right, and there's very little case law directly addressing that issue. What I find to be, there's the line that there's compelling action from a plaintiff, which based on the circumstances of these messages from the defendant to the plaintiffs, it's clear that there is an issue regarding J.N.'s will. So.
And in what way I'm not sure why we're talking about coercive control here.
Right.
Because you just said that the judge didn't find, I guess we could affirm on that ground. But telling someone, get dad to change his will back when dad hasn't changed his will in the first place, how does that control them?
Well, it's more, I would argue, the threat of legal action, because it wasn't just the one legal action. He told these parties that he contacted the FBI.
And it coerced them to do what?
Well, he's attempting to coerce them to give him information and to meet with him outside of their comfort zone. They don't want to meet with him. They've made that clear in their testimony. All
right, but tell me, let's go back to physical harm. So we've got a legal threat. What else?
So in my view of the court's findings, so on page 78 of Record Appendix 4, specifically for K.N., he found that those instances of you may not see me coming, the messages that, previously he had heard testimony about, I'm putting my metaphorical hand around your metaphorical throat, I'll beat you all. These were all statements that the court heard as threatening. He heard testimony from K.N.O. specifically that there were messages that left her feeling disturbed, that the defendant had alluded to reporting her to elder services and made reference to her stomach cancer. He had sent her 48 emails in one day. And around that same time, the plaintiff had heard the defendant yelling at their 84-year-old father, telling him to shut up. She indicated to the court that she did not want to keep her doors unlocked because she was fearful of the defendant. And it was around April 2025, she testified on cross, that it was the incessant messaging that made her afraid of him. So I'll certainly concede that she testified that there were no direct threats of violence. However, if we look at a case like Ginsburg v. Blacker, the facts are similar. In that case, the defendant came home, saw a haircut on his child that he did not like, and essentially flew into a rage. And during that hearing, the plaintiff in that case indicated that there weren't threats of harm and there was no history of physical abuse. But the fact that the behavior was escalating, the anger was sudden, it was that alone was what placed her in fear, and the court found that to be sufficient to issue a 209A.
Was K.N.O. aware of the headlock allegation?
That I don't believe is in the record.
Okay.
I don't believe so. I should say, I
Is
can't
that
speak to
evidence, though, in all three cases?
Because of the fluidity of a 209A, I would suggest that the court is permitted to take into account everything he had heard that day about the defendant's actions, because all of it is relevant to whether or not all three of these plaintiffs might be in fear. I believe—
Because it's a family relationship and every family member might
Correct.
be subject to.
Correct, and I think even if these cases were remanded, nothing would stop the plaintiffs from calling each other as witnesses should they reapply for 209A orders. So for that reason, I think the testimony is relevant and should not be excluded. However, I do believe that each plaintiff provided on their own accord sufficient evidence to request and receive the 209A order.
But you agree with the general principle that there has to be an individualized case as to each petitioner, right?
Yes, I would agree with that.
And the question is whether or not you can have some carryover effects of establishing the fear, the reasonable fear based on things that happen to another family member.
I would agree with that. And I think the trial court followed that principle, which I find especially evident where he only issued K.N.O.'s order for 6 months, and that's after hearing 2 other plaintiffs before her.
How far away did they live from each other, K.N.O. and the appellant?
That is not in the record. J.N. and the appellant are about 1.5 miles away.
So we don't even know, do we know what town K.N.O. lives in?
She lives in Tewksbury. That is in the record.
And is that also where the appellant lives?
The appellant lives in Chelmsford.
This doesn't affect the appeal, but is the order against K.N.O. has expired? Has it been?
I believe the 2-party hearing is coming up.
So to reinstate it.
I do want to address I should address the sufficiency of evidence for J.N. and D.N., if I may. First, for J.N., this is an 84-year-old gentleman. He is the father of the defendant. He indicated to the court that he was receiving increasingly threatening communications, that he doesn't know how to block people. He was unable to do that, but that the unending messages got really bad within the past few months. Both he and D.N. testified to the statement, "walk you down the ring," which they both took as threatening potentially a fight. The defendant had threatened to call the police on the 84-year-old plaintiff because the defendant believed the plaintiff had his credit cards. And what's notable is that it was on cross-examination that the defense counsel elicited testimony about the chokehold. I'll concede that the plaintiff, J.N., said that it was in a non-threatening way, but it was for no reason, and he was scared because the defendant was awful strong. He did fill out an additional affidavit that day indicating, he included messages where the defendant had indicated that J.N. had less time to live than the others. That is where the metaphorical hand around your metaphorical throat was brought up. He stated to the plaintiff, "I'm not going anywhere," and he stated, "I don't throw punches, I throw counter punches." I think what's clear from this entire hearing is that the court heard multiple metaphors, mentions of physical violence. I would argue, and I believe this is the court's finding, that the couching of those physical, references to physical violence, using the word metaphorical is probably not enough to say, well, then surely he didn't mean a single thing by it. I think something else that's relevant here as well is the defendant filing retaliatory 209As. That probably goes more to the coercive control element of 209A Section 1. However, it's important to note that it was a very real manifestation of the exact things that the defendant had been threatening over and over again in these communications.
You think filing a 209A is coercive control?
I think when
Don't we get into a lot of trouble if we start going down that road?
So coercive control includes baseless legal filings, and that's where the concern lies, because his counsel said on the record, well, he filed these when he received theirs. And the court said on the record,
I've seen an awful lot of that, right?
Right, sure. No, I totally understand. I think where the trial court made it clear, he read the affidavits, I'm not seeing any coercive control, or I should say I'm not seeing the basis for a 209A as for the defendants against the plaintiffs. And when his defense counsel attempted to go into coercive control, it's clear that the trial court did not find that to be persuasive. As for DN, I just do want to quickly touch on the sufficiency of his evidence. He indicated to the court that he received expletive-filled, insulting, and threatening messages from April 3rd to April 10th. Over and over again, the defendant threatened to contact third parties and made threats to the plaintiff's safety. Again, the walk you down the ring statement came up, which made him feel intimidated. Multiple times, the defendant tells all 3 of these plaintiffs, I'm not going anywhere, you won't get away with this, you will pay for this. And most concerning, I find, with DN is that the defendant had contacted not only the plaintiff's ex-wife, but also his workplace, which I find, again, it's that escalation of behavior. It's very similar to the behavior that's addressed in Noel N. v. Frazier F., where the defendant was threatening legal action and threatening to call, I believe, government service related to the plaintiff's family members. So there is a fair amount of case law where there does not need to be a specific act of physical violence, nor does there have to be any specific threats of violence. The escalation of anger, intimidation, threatening messages, I believe this court and the SJC has found that that is sufficient to issue a 209A order. I do want to quickly address some of the procedural deficiencies that the defendant speaks to. I couldn't agree more. Well, I agree that the lack of an objection by the defense counsel is really pivotal here, but it's also clear that the defendant did come prepared with evidence, so it wasn't the case that he didn't have anything prepared for a hearing. At no point did the defendant or defense counsel request a continuance or indicate that they were not familiar with the standard, that they needed more time. In reality, the defendant's rights to due process likely would have been more in danger should there be another continuance. Because really where 209A is concerned regarding service and notice, it's when there's an ex parte order that's been put on the defendant where he has not had the opportunity to argue against that. So I find it actually more appropriate that the court, knowing that all parties were there with counsel, including the defendant and his attorney, it's more appropriate to hear the case that day, so as the defendant is not, again, subject to ex parte orders without an opportunity to be heard. I would suggest that it's unsupported in the record that there was any evidence that the defendant did not know about or did not have access to. First, there's just no mention of it by defense counsel. And second, at one point when defense counsel is cross-examining D.N., and that would be on record appendix page 34, he mentions an affidavit. He uses the affidavit to cross-examine him. So based on all of those procedural safeguards that I believe defense counsel had, which was an understanding of the law, an understanding of the evidence, prepared his own evidence, I would argue that there were no procedural deficiencies in that regard. I know the defendant also spoke to the issue of the judge not hearing the case until later that day. The court didn't close until after 4:30 p.m., which is the normal court closing time. The court gave all parties an opportunity to present their evidence, to cross-examine, and at no point did the court preclude the defendant from entering exhibits. He simply asked that it be done in order for ease of the clerk. So for that reason, I do believe the court granted the defendant the fairness of a proceeding, which is what is required. The question is, did the defendant have a meaningful opportunity to be heard? And for a definition of that, we can rely on Idris I and Hazel H., which indicates that a meaningful opportunity to be heard is an opportunity to address the material and determinative allegations at the core of a party's claim or defense and to present evidence or on the contested facts. I believe that's exactly what the defendant had an opportunity to do. His attorney made it clear that he was prepared for that hearing. It also stands to reason that because the defendant had filed his own 209As, that they were likely prepared with that standard that day. For all of those reasons, Your Honors, I'd ask that you affirm the trial court's findings and issuing of a 209A order. If there are no further questions, I would rest on my brief.
I see no further questions. Thank you both very much for excellent, very helpful arguments.
Thank you.
The case is submitted. This concludes our session for today. I'd like to thank the court officer and the members of the court officers and the members of the court staff for their always helpful assistance. We stand in recess.